As you may know, and those of you who don't know, I'll bring you up to date. Judicial Watch uncovered the Clinton email scandal. We had asked for Benghazi documents, her involvement in the Benghazi talking points scandal, where they were lying to the American people during the last year of the in 2012, about the attack on our Benghazi special mission compound. They used these fraudulent talking points, suggesting it was a video as opposed to the terrorist attack that it was, all to protect President Obama's re-election chances. Hillary Clinton and the State Department happily helped with that cover-up. Judicial Watch basically has gotten every document there is to get on Benghazi, and we exposed that cover-up, including documents showing the White House was behind the video lie on Benghazi. All of that led to the creation of the Benghazi Select Committee. But we noticed in these documents that we were getting, there were no Clinton emails. So just to be safe, we asked again. And push came to shove, and we were insistent on figuring out where those Clinton emails were. And the Justice Department, or the State Department through the Justice Department, finally admitted to us in February of 2015 that they gave us all the emails, all the documents, other than the things they weren't giving us. And it turned out that was the Clinton email system. So in the meantime, they had tried to shut our case down without telling us about the Clinton emails that they had sitting over there at the State Department by the time of the settlement discussions in this litigation. So it was this case that exposed the Clinton emails. And of course, the rest is history. Hillary Clinton isn't president because of her email cover-up and what she was covering up in those emails. Now, fast forward to late last year, the court in the case that handles that Benghazi FOIA lawsuit that uncovered the Clinton emails, he granted us discovery because he wanted to know whether Hillary Clinton used her email system to avoid disclosure of her materials under the Freedom of Information Act. Whether, as I said, the courts were being gamed, whether this court specifically was being gamed in them trying to shut the case down before telling us about the emails. And thirdly, he wants to know whether or not there are emails to be found. So he granted us discovery, and we deposed about 11 or 12 witnesses. We received new documents and new information never before disclosed, or at least discussed publicly. And we found information that raised new questions about the Clinton email cover-up. Now, this is Judicial Watch doing this under court-supervised discovery. He granted us the specific witnesses. We had a top former State Department official come in and say, look, everyone knew there was an issue here. We had a security official for the State Department admit that Hillary Clinton was warned at least twice on her email usage. There's just new information that just came out recently that Mrs. Clinton should have been warned at least 6 times about her email usage. So all of this led to a court hearing, I think it's now 2 weeks ago. I wasn't there because I was on vacation. And during that court hearing, we asked, because we had already set it up with court filings, for some additional discovery. And of course, once again, the Justice Department and the State Department opposed us. They opposed our asking for discovery to begin with back late last year. The court was pretty upset with the State Department and Justice Department because he thought he had been gamed by them. And so we had the hearing this week, 2 weeks ago. Now, he granted us the additional discovery over the objections of the Justice Department and State Department. So I just want to repeat this. This Justice Department, this State Department is defending Hillary Clinton in court from having to answer any additional questions. Defending the State Department in court from having to answer any additional questions about the Clinton email scandal. And Benghazi, by the way, because this is also about Benghazi. Justice Department obviously also defending itself from having to answer questions about its role in the potential cover-up here. And so we got everything we asked for. I think there's, let me see what exactly. We are 7 new depositions we get to take. 7 additional depositions, 3 interrogatories. Interrogatories are written questions that someone has to answer or an agency has to answer under oath. 4 document requests, very narrow document requests. And Hillary Clinton and her top aide Cheryl Mills have 30 days, which I guess is going to run in a few weeks now, to respond to our request to depose them in person under oath, which means they would come in and our attorneys would question them under oath in person. All of this, of course, they didn't want to happen at the Justice Department. So this is why I get frustrated, folks, because I see the Justice Department defending Hillary Clinton. I see the Justice Department giving James Comey a pass. I see the whole coup cabal uninvestigated largely. I like Attorney General Barr, but it looks to me, as far our day-to-day interactions with the Justice Department, as if, I don't know, Janet Reno is running the Justice Department at times. There's no difference. It doesn't mean that Attorney General Barr doesn't agree with us on the issues that we care about, but operationally, the Justice Department hasn't changed one iota in terms of transparency. I mean, going to the mat for Hillary Clinton, despite all the evidence of the sham prior FBI investigation, Justice Department investigation, etc. So I told you the judge was upset. Well, you don't know how. Now, of course, my colleagues are telling me the details. And, you know, you're not there, so you can only tell a little bit of what goes on. And so I had a flavor. I know we've been before Judge Lamberth before. And we finally got the court transcript. So I want to tell you about the detail there, because the detail shows you just how outrageous the government misconduct has been here and the cover-up has been. Judge Lamberth is furious. During the hearing, first of all, he's clear he wants us to even do more than we were even asking for initially, because Judge Lamberth on his own specifically raised concerns about the Clinton email cache that was recently discussed in a letter by Charles Grassley, the senator from Iowa, a muckraker himself. And he, quote, wants Judicial Watch to shake the tree on this issue. He said during the hearing, just last week, the Senate Finance and Homeland Security Committees released documents revealing that Clinton IT aide Paul Combetta copied all but 4 of the missing emails to a Gmail account that does not appear to have ever been reconstructed and searched. The court thinks Judicial Watch ought to shake this tree. Lamberth also criticized the State Department's handling and production of the Clinton emails in this case. And this is the quote: There is no FOIA exemption for political expedience, nor is there one for bureaucratic incompetence. At the beginning of the hearing, Lamberth excoriates the Justice Department and the State Department after they wrongfully stated that Judicial Watch could no longer continue their discovery because they said discovery was closed. Discovery wasn't closed. State Department, this is the State Department attorney, Justice Department attorney. It is, of course, Judicial Watch's burden to explain to Your Honor why there has been good cause to reopen discovery now that discovery has been closed in this case. The court: well, I didn't close discovery, so your premise is wrong. State Department: fair enough, Your Honor. Whether you want to call it closed or not, it is still the court. I didn't close it. I said I would have a status conference after they took their initial discovery, and that's what I'm doing today. I didn't close discovery. State Department: that's right, Your Honor, but it's still Judicial Watch's. The court: so they don't need any good cause. State Department: whether. The court: today, the good cause continues from whether or not state was acting in good faith. And I'll tell you, everything they've discovered in this period raises serious questions about what the hell the State Department's doing here. It's a federal court judge exposing the State Department's misconduct as defended by this Justice Department. I tell you what, if I were the President of the United States, I'd call Secretary Pompeo, Attorney General Barr to my office, and I'd say, this is what's going on here has got to stop. You need to cooperate with Judicial Watch rather than obstruct in a dishonest way their efforts to get the facts and the court's efforts to get the facts. I don't know if Pompeo and Attorney General Barr know the level of detail what these lawyers are arguing in the State Department's legal positions, but they need to, because this is what's happening. On their behalf, they're speaking for them in court. And of course, the court rejected as I said, their efforts to derail our discovery. And he cited a prior Judicial Watch FOIA case, and this was way back when. I think the case was filed even before I started at Judicial Watch. It exposed how the Commerce Department under Bill and Hillary Clinton, yeah, they were working as president and co-president back then, were selling seats on trade missions abroad in exchange for campaign contributions. And our FOIA case, trying to expose that, was obstructed 6 ways to Sunday. Documents getting shredded, being taken out of the Commerce Department, all sorts of things happening. And this is the way the court handles the government's objections to our FOIA or discovery request here for additional discovery. I take my glasses off exactly when I need them. This is strange. I tell you another thing I didn't like in your brief. I tell you right now up front, you put in your brief the most preposterous thing I thought in your brief was the very idea. Let me read you the line. Competitive Enterprise Institute was a case of first impression, and that some district judge brought that and the Court of Appeals reversed it. Now, Competitive Enterprise Institute was a case, I think, during the Obama administration where I think the case is the head of the EPA at the time was doing government business on an account outside the agency, or they had moved documents. Now, that wasn't a case of first impression at all, says Judge Lamberth. The first impression with me was a case I had involving Ron Brown, who was the Commerce Secretary under Bill Clinton until he was killed, and the travel records of whether or not in the Commerce Department, and it was a Judicial Watch case, whether or not the Commerce Department was selling seats on trade missions. And I had a Deputy Undersecretary of Commerce who took a box of records home, and then they gave me a no records response, and in the course of that, I found out he had taken the records home, and they said they had no records. I sent marshals over, and they got the box at his house, and I ordered them, the marshals, to seize the records. That was the first case. So you're having a judge remind the government that he can send the marshals over to get records when they go missing in a dishonest way here, or any other way, on a FOIA case. The judge also stated the government had mishandled this case, and the discovery information, including of former Secretary Clinton's emails, so poor, it had mishandled this case and the Clinton email issue so poorly that we will have the ability, or likely have the ability, to prove bad faith, which is important because we could get attorney's fees and other relief, by the way, as the judge reminded us in terms of getting the marshals out there to get documents. Judge Lamberth detailed that the State Department spent 3 months from November 2014 trying to make this case disappear. That's a quote. And that after discovering the State Department's actions and omissions, now we know more Now we know more, but we have even more questions than answers. So I won't hold it against Judicial Watch for expanding their initial discovery request now. So he granted us the additional discovery. And I want to read you, this is what happens. He's hearing the argument from Judicial Watch. Our lawyer, you've probably seen her if you watch our YouTube channel, Ramona Kotka. She was on Chris Farrell's On Watch last week. I interviewed her a few weeks ago as well. I encourage you to watch both interviews. So Ramona was our lead attorney at this hearing. So she gets to make her argument, and then the Justice Department gets up and makes its argument. And then the judge said, I'll tell you what, I'm going to take a break, I'm going to go off the bench for a bit, and I'm going to come back. And he came back and he made the following oral order. First, let me clarify the government's misunderstanding. And I'm going to read it to you because he goes on at some length, but it's important because A, no one else in the dishonest liberal media that's still trying to protect Hillary Clinton while improperly targeting President Trump, or allowing the government to improperly target President Trump, they're not going to tell you about it. You're only going to hear this from me. You're only going to hear it from Judicial Watch. Congress won't do anything about this. The media won't do anything about this. And the Justice Department won't do anything about this. But you can get, it's incredible that it's Judicial Watch that is having to still pursue this information. And again, getting new information that the IG of the State Department didn't get, that the FBI didn't get, and or ignored if they did get it. And of course, the Justice Department was involved in the cover-up as well. And it's continuing. And thankfully, we have a federal court judge who's as outraged about this, properly so. He doesn't scream about it like I do. But I'm going to read you what he wrote, or what he said from the bench. First, let me clarify the government's misunderstanding. We're not reopening discovery here. Discovery never closed. Back in January, I said, quote, the court will hold a post-discovery hearing to ascertain the adequacy of state searches, to determine if Judicial Watch needs to depose additional discovery, witnesses, including Hillary Clinton or her former Chief of Staff, Cheryl Mills, and to schedule dispositive motions. And dispositive motions, I believe, I'm warning you, I'm not a lawyer, are the sorts of motions that would end a case once they're filed. So June 19th was a checkpoint, not a finish line. And whether Judicial Watch previously knew about some of the other individuals it now wants to depose is beside the point. They tailored their initial discovery request to the facts and questions then before the court. And I'll tell you, when you read, because this transcript is online, so we'll provide a link to this, I hope we do, and you can find it at our website as well. The Justice Department was attacking us in the court hearing. Suggesting we were pursuing this in bad faith. This is the Justice Department attacking Judicial Watch. And the judge is defending us. Now we know more, but we have even more questions than answers. So I won't hold it against Judicial Watch for expanding their initial discovery requests now. Remember what got us started down this path in the first place. In late 2014 and early 2015, at least some State Department officials knew Secretary Clinton's emails were missing. They knew Judicial Watch didn't know that. They knew the court didn't know that. But the department pressed forward trying to settle the case. So I authorized discovery into whether these settlement efforts amounted to bad faith. Now the government says, quote, there is simply no factual basis to justify any further discovery on that subject, unquote. But Judicial Watch's most recent submission lays out the following. It appears that in the middle of 2013, State's Office of Information and Program Services launched an inquiry into Clinton's emails practices. That's the agency of the State Department that handles records. It appears that in August in 2013, that office directed FOIA respondents to stop issuing, quote, no records located, unquote, responses to FOIA requests for Clinton emails, meaning they knew they had Clinton emails and they couldn't pretend otherwise anymore. It appears that by the summer of 2014, State knew a large volume of Clinton's emails had never been searched, potentially violating FOIA and record management obligations. It turns out State had a standing meeting every Wednesday afternoon during the summer of 2014 to discuss Clinton-related FOIA inquiries. Attendees included Secretary Kerry's Chief of Staff, his Deputy Chief of Staff, the Deputy Secretary for Management and Resources, the Assistant Secretary for Legislative Affairs, several attorneys, and Patrick Kennedy, the Undersecretary for Management. That was every Wednesday afternoon. The cover-up was at the top, certainly in the State Department. It appears that in August 2014, State began planning for media investigations into Clinton's emails. Remember, we didn't find out specifically about the Clinton emails until the New York Times first reported it in, I think it was March of 2015. Almost about a half a year later. It appears that in November of 2014, State told Judicial Watch it performed a legally adequate search and tried to settle. In fact, I think in my original opinion on authorizing discovery, I noted that State had given a draft Vaughn Index to Judicial Watch at that time. I don't think I've ever seen that, but I think it was given to, in my opinion, I said it had been given to Judicial Watch. Indeed, State spent the next 3 months from November 2014 trying to make this case disappear. They kept doing it even after they became into the possession of Clinton's emails. Now, what's a draft Vaughn Index? It's a privilege log, essentially. It's a listing of documents and the reasons they're being withheld in whole or part. It's supposed to provide enough information to the requester so that they can decide whether to pursue the documents, and it gives supposedly to give enough information to the court so that they can look at it and figure out whether the exemptions are valid under law without having to look at the underlying documents. It doesn't always solve that issue, but that's the purpose of it. And in giving us a Vaughn Index, it didn't list any of the Clinton emails. The judge is highlighting that here. Judicial Watch wants to follow up with the state attorney assigned to this FOIA request to participate in settlement discussions and negotiations. That seems reasonable to me. State wants to ask the department official responsible for overseeing FOIA requests about why he directed his office to stop using, quote, no records located responses to FOIA requests related to Clinton's emails, if that in fact is what happened. I'm curious too. They want to ask the current department FOIA overseer more about what went on in those weekly 2014 meetings. I look forward to hearing what he says. They want to ask the Justice Department attorney who led the settlement negotiations to divulge when he learned Clinton's emails were missing. He must answer. Another reason we had this initial discovery was to see if Secretary Clinton intentionally attempted to evade FOIA by using a private email. When Judicial Watch deposed the deputy director who oversaw State's FOIA responses, he recalled an instance when his office found an email from Clinton's private account, and the public affairs team said, "Remember, you're not supposed to use that email." How can you spin that? I agree with Judicial Watch that it's worth deposing the State Department records officer who personally reviewed archiving procedures with Secretary Clinton and her departing staff to see what they discussed. I also think that Judicial Watch is justified to seek more information about how Secretary Clinton ultimately determined which emails were public records and which were private. Remember, that's how all those emails got destroyed, or so we're being told, because they were, quote, private. That wasn't true. The final reason I authorized discovery was to determine whether the State Department adequately searched for records responsive to Judicial Watch's FOIA request. Now, the government seeks to duck behind an unpublished D.C. Circuit opinion from 2018 holding the government had already taken every reasonable action under the Federal Records Act to retrieve Clinton's 30,000 missing emails. And no imaginable enforcement action could recover any more. But just last week, the Senate Finance and Homeland Committee released documents revealing Clinton IT aide Paul Combetta copied all but 4 of the missing emails to a Gmail account that does not appear to have ever been reconstructed or searched. The court thinks that Judicial Watch ought to shake this tree. And the court agrees with Judicial Watch that it should talk to 3 never before deposed state officials who raised concerns about Clinton's private email use all the way back in 2009. Remember, that's when she started. There is no FOIA exemption for political expedience, nor is there one for bureaucratic incompetence. The government also tries to say this court is no longer presents a live controversy. This is wrong. Judicial Watch can still obtain fees if they prove agency bad faith. I'll close with this, the court concludes. When I authorized discovery back in December, I described my goal to rule out egregious government misconduct and vindicate the public's faith in the state and justice departments. That's still my goal today. This isn't a case I relish, but it's the case before me now, and it's a case of the government's making. The court authorizes Judicial Watch to take the additional discovery described in its status report. Except for deposing Secretary Clinton and her Chief of Staff, Cheryl Mills, I will give their attorneys 30 days to file any additional responses, any additional opposition in their depositions, and 10 days thereafter for Judicial Watch to file a reply, and I'll issue a separate ruling on that. Otherwise, the discovery should go forward, and all of it should be completed by December 13th, and a status conference will be held, scheduled on December 19th. So there you have it. So when the liberal media tells you there's nothing more to be found about the Clinton emails, there's no more justice to be done, I just proved that to be the lie of the century. And what's unfortunate about this situation is that it's Judicial Watch, once again, doing the work, doing the heavy lifting, over the objections of the Justice Department, over the objections of the State Department. And this is just one of the cases on the Clinton emails that we faced outrageous obstruction. We battled the Trump Justice Department and State Department, as the judge noted, on that records case. All the State Department needed to do under the law, we alleged, was send a letter to the Justice Department talking about emails going missing. And they went crazy about that because they knew that might spur an additional criminal investigation. So they went to the FBI and had them write up their reports on how they searched for Clinton emails, that there was nothing else to be done. Unfortunately, the court bought it. We also demanded a damage assessment under the law of classified information in Hillary Clinton's email system. Meaning if something when there's reason to believe that classified information is on a system, on unsecure systems or otherwise unsecure, intelligence community is supposed to do a damage assessment, spillage, to make sure that nothing happened. They didn't do that under Obama. We asked the Trump administration to do that. We were opposed by the deep state like you wouldn't believe. And when the government doesn't want to do something, especially on Hillary Clinton, it's hard to convince the courts otherwise. Like I said, President Trump, I would have an all-hands-on-deck meeting on this. But thankfully, Judicial Watch is doing this work. It's work that's not being done by the Justice Department, the State Department, Congress, or the media. It's little old Judicial Watch, and we're only able to do this with your support. So I want to thank you for that.